The topic was selected by our two speakers tonight, Ian Roberts SC and Richard Cheney SC, in light of what we see as, what we as a Chamber see as being an increase in the number of these types of cases, certainly coming through our practices here on this floor, related of course to the fact that we are going through something of a boom in terms of construction. The talks are divided into two parts. Ian Roberts, who practices predominantly in building and construction law, will talk to you about interim applications involving the duty of care in 177. And then Richard Cheney, another of our silks, who practices in both building and construction but also in professional negligence, will talk to you about the substantive matters and the development of the recent jurisprudence on section 177. So I'll start, if I may, by inviting Ian Roberts to talk to you about interim applications.
Thank you, everyone. I thought it was actually mood lighting, but it's a little bit improved, so we can actually see the paper now. Most of us in Sydney, like many people, most of the people in Australia, live in very highly populated cities. We all live on top of one another, with houses adjoining, with buildings virtually on top of other buildings, and in some cases built millimetres apart. And the only way to develop effectively is essentially to dig a very deep hole right next to the building next door. As I said in the paper, what could possibly go wrong? Now, the owner of land has a right to expect that the adjoining properties will not remove the support that land provides the owner's land. But there's not much point in enforcing that right if by the time the matter gets through the court system and the matter is determined, your building is lying in a pile of rubble at the bottom of the neighbour's pit, a little like the Red Keep in Game of Thrones. So what I'm going to deal with in the first part of this paper is the steps you need to take to protect that right so that you can get to a stage and have the substantive rights determined by the courts. So we've broken it up into two parts. I'm going to deal with that first, as Derek said, and I'm going to pass it on to Richard, who will deal with the substantive issues that you'll need to understand in order to take the matter through to a final determination and obtain final relief. Now, let me just make sure I get this right. Oh, look at that. In any potential proceedings, when looking at interim relief, you need to identify, and it's critical to identify, what is the final relief. You need to work out where you're going so you can work out how to get there. So the first thing to do is determine what is the basis on which I will be applying in due course for final relief, and in most cases that will be section 177 of the Conveyancing Act that Richard will take you through in due course. Now, I haven't put it in the slide, but I've included paragraph 5 of the paper, the text of 177, so you know what it is referring to. And I think Richard might have probably done the same thing, so you'll have that before you. Dealing with the interim relief, the court has power to grant interlocutory and interim injunctions, a general power in section 66(4) of the Supreme Court Act. It also has an inherent power, and I've provided the authority there and in the paper. That won't come as a surprise to most of you. What I'm going to spend most of the time up here on is how do we do that? How do we get the interim relief? The removal of support for land often manifests itself in a number of different ways, but consistently manifests itself. There may be voids appearing, there may be depressions in the land, often near the boundary. There may be shifts in the surface, in the hard surfaces, the concrete pavements and so on, cracks in the building, and often the building itself inside with brittle finishes displays a range of different types of damage, which will give you, or give your client, an indication that something has gone wrong and there's settlement occurring. And ordinarily you will associate that with an activity being done be undertaken on a neighbouring property. When that occurs, two things have to be done. You need to identify the damage. You need to go around and document it in some way. Photographs are great. You need to identify the cause of that damage and ultimately be able to link the two. The difficulty you've got with obtaining interim relief is all of this happens very quickly. Well, difficulty your client will have. You'll get a call from the client saying building cracks are emerging all over the building. There's an excavator in the hole next door. They're digging a 5-metre pit. There's shoring going in. There's vibration going on. All sorts of things are happening, and I'm noticing changes in the building. You've got to act very quickly. You've got to get in a position to get the relief you need to protect the position so that you can then, as I said, go on and enforce your right to maintain that support. So it's important to document and photograph and record all of the damage and tell your client to record all that damage very, very quickly. Now, what evidence you need in each case will depend on a case-by-case basis. Often you won't have time and you won't have the luxury to have an expert report obtained in the short time available between identifying the problem and having to run up to court. 9 times out of 10, the evidence will be something like the building was blissfully devoid of any damage for all of its relatively long life until the day after the excavation began, and suddenly all these cracks and all other damage appeared, and that will allow a court to join the dots and draw an inference. So, before you get to court, you will have identified your cause of action, you will have identified the damage, you will have been able to link by reference to the nature of the damage, the location and the activities on the adjoining property, some causal connection, even though you may not have an expert's report that would prove that for the benefit of an application for final relief. At that point, you really need to go to the offending party and try and extract from them an undertaking to stop. The courts encourage it. One of the first questions you'll be asked when you get to court is, well, have you sought an undertaking from the neighbour to stop digging the hole, to stop putting in the sheet piling, to stop doing whatever it is that you say is causing the problem. It's important to do that because the courts expect, practitioners particularly, but they expect the parties to try and deal with these issues without the need to involve the court. So you ought to ask for that undertaking often, and frequently it's not given, at least not at the outset. But nonetheless, you want to be in a position when you get to court to say, we tried, we rang them up, we wrote to them, we asked them to stop. There was damage occurring, it was clear that it was caused by the activities in the neighbouring block, and they wouldn't stop. They told us, don't talk to me about boats, buddy, I know boats, and kept going. So you get to a stage where you need to go to court. Most of these applications are made in the equity division, if not all, although you can make applications in other divisions. Practice Note SC-EQ 8 deals with urgent applications in the equity division, in the equity list and in the expedition list. And you can make an application in that list. Ordinarily, in my view, you're better to go to the technology and construction list, which has its own duty judge. And paragraph, I think it's 46 of the Practice Note SC-EQ 3 expressly provides that urgent applications may be made and gives you an understanding of what to do to make them. Effectively, you ring up Mrs. Sutton as the associate to His Honour Justice Hammerschlag, unless someone else is looking after the list, and you ask if you can come up and see the judge. You've got an urgent application, and he or she, whoever the associate is at the time, will give you the relevant details. But you need to be ready to go before you make that call. There are a number of documents you need to prepare. You need a summons, you need affidavits, and you need draft orders. This is an application that's made on summons. You don't ordinarily, for the interim relief, need a technology and construction list statement, and you don't need a notice of motion. Many times I've seen material come up to be settled for the purposes of an application and there's notice of motion, you don't need it, the courts don't need it, the judges discourage that. What I tend to do is, in the summons, have a separate section dealing with each of interim and final relief. Sometimes there'll be more causes of action available to you than you need for the interim relief. So in that way, you can have a heading, which I tend to have a heading and it says interim relief, and I list the orders that I want for the interim relief. I have a heading, final relief, and I list those. And that way you can go to the court and say, Your Honour can disregard orders 4, 5 and 6. We're dealing with 1, 2 and 3 at the moment. So there's an easy demarcation between the two. Now, as I said, the application will be made relying on Section 177 of the Conveyancing Act. That replaced what used to be made, an application used to be made based on nuisance, with an application effectively in negligence. Now, we're all familiar with the elements of negligence, and we'll all be familiar with concepts such as the duty to exercise reasonable care. In Lynn International and Makalongo, which Richard will take you through in a little bit more detail later on, the Court of Appeal made it clear that although the section doesn't expressly say reasonable care, what it is imposing on an owner of adjoining land is an obligation or duty to exercise reasonable care. Now that'll immediately ring some alarm bells in terms of what you need to prove. Effectively, you'll need to show what the acts were, what was done. You'll need to show what the effect of those activities were. What it's caused damage on your property, you've got cracking, you've got depressions, you've got voids and so on, and there's clear evidence of settlement of the property. And you need to show that there's been an absence of reasonable care that's brought about that damage. That third category ultimately will probably require expert evidence. But as I said earlier, you're often not going to have the luxury of getting an expert report in the short time available between identifying the problem and then running up to court to get interim relief. But as I said, there are ways you can deal with it and ask the court to draw an inference if the evidence in the photographs of the damage, perhaps the location of the damage in relation to the adjoining property, if the inference is available from what is disclosed in the documents and the photos, then you may be able to draw that inference. But as I said, it's really a case-by-case basis. But nonetheless, you'll need to demonstrate that the damage was brought about by an absence of reasonable care. If you're going to rely on documents and photographs, you'll need to prove them by the lay evidence. You'll need to get someone, the owner, committee member, occupant, or someone who is able to say, I took the photos, I noticed the cracking, here's a photograph of the cracking I saw in the northwest corner, right adjacent to a 15-metre excavation, showing all sorts of things. And someone needs to give actual evidence of what has happened and identify what the photographs show and prove that they were taken, where they were taken, and so on, in the normal way. If you can get an expert, all power to you, great. Often, as I said, you can't. If you can get an expert and the expert can deal with both the causation aspects and can deal with other aspects such as whether the activities are reasonably necessary for the purpose of achieving what the neighbouring excavation contractor owner is trying to do, then all the better. You may be able to get evidence that will assist in questions about the balance of convenience by saying, for example, they're digging in a certain way, but that can be achieved in a different way that causes less vibration, that causes less effect on the demarcation line between the properties and is less likely to cause the damage that has been identified in the photographs. And that's going to be relevant in due course to your application because it'll be relevant to the question of the balance of convenience. In these applications, you'll often be making them ex parte. They're often for relatively short term, but nonetheless, the court will require the applicant to provide the usual undertaking as to damages. That's a concept that most of us are familiar with. It may not be familiar to your client, particularly an unsophisticated client, an owners corporation committee member, or just the owner of the occupant or owner of a house, and so on. So you need to explain that to them before you get to court. There's nothing worse than getting through all of the steps that you need to get through, only at the point when the judge is about to make the orders, and the judge will say to you, and normally to counsel, Mr. Roberts, I take it you give the usual undertaking as to usual undertaking as to damages, and you turn to the solicitor and with a question mark on your face, and the solicitor turns to the client, and the client is going, well, what's that? You got to get that out of the way early. You got to be in a position at the outset to say, and Your Honour, my client gives the undertaking as to damages, and get that out of the way. You can do it in writing, and that's not a bad way of doing it. When you come up to court with your summons, your affidavit material and your draft orders, not a bad idea to have the undertaking as to damages in a document. You can hand the whole lot up to the judge, and it makes life easier for the judge. I've given you, I think, the reference in the paper to the effect of the undertaking and the effect of when in those circumstances when the action for final relief fails. That's when the undertaking comes into play, and damages will be assessed on the basis of what's just and equitable or fair and reasonable, and the authority is Beecham Group, which I've provided at the foot of page 6 of the paper. So, you've given the undertaking, you've prepared the documents, you've arranged to come up to the duty judge, and you're before the judge. To succeed, there are two things you need to show. You've got to show you've got a good arguable case, or a serious question to be tried. It's expressed in different ways in different cases. And you've got to show that the balance of convenience favours the order. A good arguable case will depend on the nature of the damage, the nature of the case itself. It's been expressed as a prima facie case with real possibility of success. It's not a particularly high bar, but you do need to demonstrate that you've got a prima facie case in that way. And that's from Beecham. The balance of convenience is a question that the court will determine by weighing up the ongoing damage, the adverse effects of the continued activities against the adverse effects of an injunction being imposed on the person undertaking those activities. And often that adverse effect is significant. If it's a major development worth many millions of dollars, and the effect of your injunction is to bring it to a grinding halt, then that will have a serious effect on the ability of that development to continue, and the contractors that are involved in the development. So it's an important weighing up exercise. It's sometimes lessened by what is more common nowadays than might have been once, and that is to have a very short interim injunction with, particularly in the technology and construction list, with the directions on a weekly basis every Friday. On any day of the week, the judge will normally give you an injunction up until the next directions hearing, and then you can renew it. But by the time you get there, the parties have been forced together, if they haven't been forced together earlier than that. But it gives the opportunity to put a regime in place that alleviates problems that might have been continuing to be caused by the ongoing activities. One of the things that will be relevant too is the evidence that you hopefully have been able to get, perhaps through your expert evidence or otherwise, of alternatives that are available, that may be available to the activity that's being done or the way in which it's being done. Alternatives such as the manner in which the excavation or the piling or whatever it is that's being carried out, the manner in which that is being done that's causing the problem. If, for example, a contractor or adjoining owner is continuing to undertake excavation in a certain way, when there's evidence that there is another way of doing it that's not going to be as damaging, but nonetheless continues in that way, then that's going to affect that weighing exercise, a balancing exercise, when the court comes to look at the balance of convenience issues. The other, another important thing that you need to deal with your client at an early stage is that applications made on an ex parte basis, which these applications will often be, will require a duty of candor on the part of the applicant. Most of us are familiar with that, but the clients won't be, ordinarily won't be. The duty and the basis of the duty was explained by the full court in Town and Country, and I've given you the reference there. The rationale behind the principle is clear. It is of the utmost importance in the due administration of law, and the courts and the public are able to have confidence that an ex parte order has been made only after the party obtaining it has complied with its duty to disclose all relevant facts. Now, as I said, most of us are familiar with that. But a client who's not a professional litigator, who is unsophisticated in these types of cases, will justifiably be agitated when he or she sits in court and watches the advocate explain all the bad things about their case, all things that you would ordinarily in a situation where the duty did not apply, otherwise not disclose. You need to be able to say, you need to explain to the client at the outset and before you get into court, there is a certain duty that we have to the court. We need to explain things, the good, the bad and the ugly. We need to explain to the court that there are facts that don't go in our favour. We'll ultimately overcome them when we get to final relief and a final determination, but nonetheless we need to disclose those things. If you do that at the outset, most clients wouldn't have a problem. But if the first time they hear all these things is when the person they're paying to stand up and fight for them starts coughing up all these terrible things about the case, then things will go pear-shaped. Now, if you're successful, and hopefully you would be, you will have taken up to court a copy of the orders that you need. Sometimes those orders are made in the form that you've already set out in the document. Often they're not. Often there's a bit of negotiation between the bench and the bar table about the form of the order and what might have been stepping a bit far over the line or asking too much. It's often good to have a soft copy of the document on a laptop up in court, and if there is to be any changes, bearing in mind the urgency of these applications, you can make them on the run, change the document and then email it straight to the associate, and then the orders can be made in that form. That'll save a lot of mucking around, going back to the office, going back to chambers, sending versions up to the judge and so on. The next step for you, and it's a fairly easy step for you to take, is to take out the orders. That's an odd term, and it's a bit of an antiquated term these days. In the old days, what it meant was you'd go to the registry and you would have your copy of the document, and the judge's book would be on the other side of the counter, and you would read yours, and the registrar would follow you and see if you produced the orders in precisely the same way as the judge had recorded them. These days you've already emailed a copy of the order to the associate, and you go down to the registry with the associate normally, or a tippy, and you have the orders entered in the system, and they give you a sealed, signed copy of the orders, an original version, and armed with that you can then serve the document. Ordinarily you'd need to serve the summons and the affidavit, but you would certainly serve the order on the party responsible for the activity that's causing the problem. But the purpose of taking them out is to get that original signed copy that can be enforced immediately, and to fail to comply with that order would be a contempt. The orders ought to, if you can, and if you don't, I suppose the judge will probably impose this on you. It will have to include the method by which you will serve the orders. Often, and I've had a number of cases where this has happened, by the time you've taken the judge through the material, got the orders, got to a stage where you're ready to get a stamped copy, it might be 6, 7 o'clock at night, and everyone's gone off site, but you need to get it to somebody before they start up the machinery again, 6 o'clock the following morning. So there may be a need to get a few versions of the method by which you'd serve the document. It may be email it immediately, leave it at an office overnight, and then put it on site the following morning by 6 o'clock, just to make sure that the other side gets notice of the orders that have been made. Now, as I said, the orders are normally, the interim relief is normally only going to be a short period of time. The judges don't like these interim orders, for obvious reasons, dragging out, and they will ordinarily, if they don't require you to come back to the next directions hearing on the following Friday, they may say, I'll give you an injunction for a day and I'll list it tomorrow at whatever time. That'll give you time to get the other side up here, so it's no longer an ex parte application, it's on notice, the other side is there, they can say what they want to say, explain why they need to jackhammer all day and create rubble in the yard next door. And at least both sides have had an opportunity by then to say their piece, and the matter would then progress in the construction list in the usual way. Other occasions, the court may give you the injunction to midday on Friday, when the matter will be listed in the usual construction list for directions. But by then, hopefully, you will have had time to speak to your opponents, put together either a voluntary regime in place so that the damage can be avoided or further damage can be avoided, and if not, you may need to renew the injunction on the Friday in the directions list until the matter can be determined, or until the matter can be resolved on an interim basis, so that the final relief can be sought in the usual way. So, with that in mind, I'm going to pass on to Richard. I think it's probably better to leave questions to the end of yours. So we'll do that, and so I will leave you in Richard's capable hands.
Thanks, Ian and Derek. Hopefully you'll all have a copy of the paper that I prepared. It traces, among other things, the history that led to the enactment of Section 177, including what was known in the common law as the rule in Dalton and Angus, which provided that there was no general right of support for improvements on land, or as it was explained later by a Supreme Court judge here, if it was a rule to the effect that if an individual built upon their property and in so doing added unnatural weight to those lands, they could not recover if their neighbour, in excavating the adjoining property, removed support for that land and caused damage to the buildings so situated. This is because, although neighbours were obligated to provide support for each other's land, their obligations did not extend to supporting the additional weight that buildings placed on contiguous yet separately owned lands, which only has to be stated to be recognised as a pretty unsatisfactory state of affairs. And it was because it was such an unsatisfactory state of affairs that the New South Wales government appointed the Law Reform Commission to inquire into this whole area, and the Law Reform Commission's report, which was published a few years later, ultimately led to the enactment of Section 177. So beyond that, I don't propose tonight to say any more about the history. It's set out briefly in the paper. I thought it might be of more practical benefit tonight to focus on what I think are the 8 key things to take from the plain words in section 177 and the authorities that have construed those words. And at the risk of stealing my own thunder, I've collected the 8 key points in paragraph 6 of the paper. I was planning to say something briefly tonight about each of those points. But it might first take a moment to look at the wording of the section. I've reproduced all 13 subsections of section 177 in the paper, but I just wanted to highlight a few of those subsections tonight. Subsection 2 is the real meat of the provision. It provides that a person has a duty of care not to do anything on or in relation to land that removes the support provided by that land to any other land. And the subsequent subsections that I was going to take people to are subsections 3 and 4, which provide definitions of what supporting land constitutes. And importantly, subsection 4, which provides that the duty does not extend to any support that is provided by a building or structure on the supporting land, except to the extent that the supporting building or structure concerned has replaced the support that the supporting land in its natural state formerly provided. So in the typical example, a retaining wall that is installed to replace the support that was previously given by the natural land, or the land in its natural state, if in subsequent excavations the defendant removes the retaining wall and causing damage to the neighbour's building, then that will be taken to be a breach of the duty. And subsection 5 provides, somewhat curiously, because I've not actually seen this in practice, but and might be that somebody here has, but it contemplates that neighbours, if I can use that term, might enter into agreements pursuant to which the duty is excluded, although it's hard to imagine in what circumstance that would ever happen. And the only other matter in the section itself that I'd highlight is the fact that the statute expressly abolishes what had previously been the common law action of nuisance in this area. I've got a matter that arrived recently. It's an appeal from a district court decision that was handed down last month, in which the plaintiff, the original statement of claim, or the statement of claim that was in play when the case was opened, pleaded the claim in common law nuisance. It was a neighbour's excavation on a neighbouring property causing grief to the plaintiff's property, and the plaintiff's counsel had to go through the somewhat humiliating exercise of abandoning on the opening few minutes of the case the entire pleaded case and opening orally on a claim based on section 177. So, query at what time in the preparation of that matter it dawned on the plaintiff's camp that there was no longer any common law claim in nuisance available. The first point I think to notice about the duty, if I can go back to subsection 2, is that it's one that seems to obviate the usual inquiries that are involved in determining whether a duty of care exists. People will be familiar with the proposition that there are recognised categories of relationships where a duty will be held to exist, the doctor-patient or the teacher-student or design professionals and principals, for example. And then if one has a matter where the relationships don't fall into those recognised categories, it's necessary to go through the exercise that Justice Alsop referred to in Caltex and Stavar about searching for the salient features of the relationship that might point to a duty. But here, in this particular context, it appears that each of us is burdened by this duty. That is, a person has a duty of care not to do anything on or in relation to land. So it's not necessary as a result of the section to go through the exercise of identifying who might be caught by that duty. It seems to be a duty that falls on each of us. It seems also to be the case that it's possible to breach the duty without having any direct or physical involvement in the works. And Ian mentioned the Marcolongo decision, which I've referenced as well in the paper, and I'll come to it. But Marcolongo is an example of a case in which the defendant developer was held to have breached Section 177 in circumstances where the developer, the entity, had absolutely no direct involvement, at least, in the excavation works that caused grief to the plaintiff. If you'll suffer me to burden you with some of the short facts in Marcolongo, Mrs. Marcolongo owned a property at Mona Vale, a house that I think the family had lived in for 60-odd years. Lim International, the developer, bought the house next door, demolished it, and started excavation and shoring works to erect a 3 or 4 storey block of units beside Mrs. Marcolongo's lovely house. And in the course of excavating at the boundary in preparation for shoring works at the boundary, which involve sheet piling being installed, quite heavy gauge, 6mm thick steel sheet piles being driven into the sand at Mona Vale by a process of vibration. Mrs. Marcolongo's footings were undermined. The sand simply leached away from underneath her footings. And one of the failings that was found against the developer, Lim, and the shoring contractor at the time, the sheet piling contractor, McDonald Sheet Piling, was that there was supposed to be, as part of the scheme, some temporary propping works under Mrs. Marcolongo's footings to make sure that during the period that this heavy vibration was happening, no loss of support was suffered to her footings. And it was found as a fact, and not overturned on appeal, that that the temporary propping works were so negligently done as to have created the circumstance in which, when the subsequent sheet piling vibration work started, there was no way for the support under Mrs. Marcolongo's footings to remain adequate, and she suffered what was ultimately found to be nearly $2 million worth of damage. And I've got a particular familiarity with this case. I was in Marcolongo for the insurer of the by then deregistered McDonald Sheet Piling. So QBE was a party to the proceedings and on the hook effectively for any failing on the part of McDonald Sheet Piling. But one of the curiosities of the Marcolongo case is that the developer argued throughout that for the purposes of Section 177, the developer should not be taken to have done anything in relation to land, because all that occurred was that in the negligent performance of the temporary propping by McDonald Sheet Piling, grief was suffered by Mrs. Marcolongo, and the developer itself did no more than create the circumstance, that is, by obtaining development approval and by obtaining a construction certificate. It did no more than those things to cause the environment in which the shoring took place negligently. And that has a certain superficial appeal, I suppose, that argument. But it was one that found no favour with the trial judge, and it found no favour in the Court of Appeal. And I'll say more of it later, but the short point for the moment is that Marcolongo is an example of a situation in which an entity that had actually no physical involvement in the works that led to the loss of support was nevertheless found to be in breach of the duty. The next key feature is to observe that the section does not extend to omissions. One curious matter of history is that the recommendations of the Law Reform Commission report that led to the enactment of Section 177 included a recommendation that the duty extend to omissions. That is, the recommended provision by the Law Reform Commission was read effectively that everyone must take reasonable care that they do not do or omit to do anything on or in relation to land which might cause loss or damage, etc. And that recommendation was not carried forward into the legislation as enacted, and why that is probably doesn't matter for present purposes. All that does matter is that the authorities have construed the section as not capable of being breached by failing to do something. But in the paper I posit this proposition that it might be possible to characterise a failure to act as in fact involving a positive act of commission. That is, or for example, an example is seen in Associate Justice McCready's decision in Piling and Prynew, where the defendants argued that to the extent that they were at fault in the events that saw the neighbours' building undermined, their fault was in failing to fill a hole that developed during the excavation, which the referee found, because the matter went to reference, the referee found that had the hole been filled during the excavation, then that would have stopped the leaching of support from below the plaintiff's property and stabilised the undermining that had started to occur. And yet the referee construed that failure to fill the hole as really a positive act. That is, that the breach of duty lay in permitting the excavation to continue with the hole in place or with the hole unfilled. And that finding by the referee was upheld by Master McCready on the adoption application. And it perhaps points to a tendency on the part of the courts to not permit defendants to avoid liability on the basis that their failing was one of omission. It'll usually be possible, I think, to dream up some characterisation of what occurred as involving a failure, a positive failure, that is an act of effectively the defendant doing something in relation to land that caused the loss of support. Another key feature of this is that, and I think Ian mentioned the fact that despite the absence in the section of any reference to the need to show reasonable care or use any reference at all to the term reasonable care, the courts have construed the duty as one that's breached only when there is a want of reasonable care. And that's in some respects curious, given, if I can take you back to subsection 2, that the duty reads in plain terms that a person has a duty of care not to do anything on or in relation to land that removes the support. And without much sophisticated analysis, you could say of that duty that it's possible to breach it from the moment you do anything, even without fault, that causes a loss of support. But in any event, the courts have construed the section as importing a notion of reasonable care. I've extracted in paragraphs 24 and 25 two examples of authorities where that has been found by the courts, and indeed the most recent one was only last month in a decision of Justice Stevenson in a matter of Southern Cross Construction, in which I think Derek was one of the defendants in that. Yeah. Yet another Derek Hand triumph. Ian mentioned this as well. In Markalongo, the leading judgment was delivered by Justice Campbell in the Court of Appeal, and His Honour identified 3 questions that need to be asked in order to determine whether the duty has been breached. And I've extracted in the paper in a rather lengthy extract from the judgment in Markalongo, where the context in which Justice Campbell landed on these 3 questions. I mentioned earlier, this provision that falls out from, I think, subsection 8 of the section, that to the effect that the section doesn't operate to preclude the removal of support provided by a building or structure on the supporting land unless the building or structure replaced support previously provided by the supporting land in its natural state. And, it's hard to imagine where that provision, that aspect of the provision, would have much work to do. I mean, in the typical excavation case, there won't be an issue as to whether the land in its natural state previously supported the plaintiff's land. It's hard to conceive of a situation where that subsection would have any work to do. The other point that spills out from the subsections is that any loss of support, any reduction in support constitutes a breach. It's not necessary to show that all support that is being provided by the building's foundations or footings has been taken away. It's sufficient to show that there's been any loss of support, and a breach will be made out. And I emphasised when we were going through the subsections earlier that there's this curious provision that neighbours may contract out of or modify the duty of care. One important feature, I think, and I haven't canvassed this in the paper, but the section doesn't eliminate the need to determine causation by applying Section 5D of the Civil Liability Act. And importantly, these two subsections, firstly, subsection 1B in particular, a determination that negligence caused particular harm comprises the following elements, and B, that it is appropriate for the scope of the negligent person's liability to extend to the harm so caused. And then the second subsection a later subsection in Section 5D, subsection 4, which provides for these, what was said in Marcolongo to be a normative evaluation or a normative judgment in determining whether or not and why responsibility for the harm should be imposed on the negligent party. This was a live topic in Marcolongo because the developer argued, in the Court of Appeal at least, although he didn't run this argument in the trial, that even if it were found that he was in breach of the duty, because it could be said that in allowing the works to proceed, it had done something in relation to land that caused Mrs. Marcolongo's property to be undermined. Nevertheless, it was not appropriate to visit responsibility for the harm on Lim in circumstances where, Lim argued, Lim had no control over what was being done by the experts, that is, the sheet piling and shoring contractor, McDonald. Now, I must say, this came up in the Court of Appeal, and we're in the Court of Appeal only because at trial, the judge found that Lim was 25% responsible for Mrs. Marcolongo's damage, and my insured, QBE's insured, McDonald was in for 75%. Lim was unhappy with that apportionment and took the matter to the Court of Appeal. And on this question of whether the apportionment was appropriate, I found myself in the curious position of trying to hang on to it. We were quite chuffed at getting 25% out of Lim. But the plaintiff, Mrs. Marcolongo, who was effectively the first respondent to the appeal, had a rather keen interest in Lim getting up on the argument because Lim was of dubious solvency, and whereas QBE was probably good for the other 25%. So I found myself with the advocate for Lim, supported wholeheartedly by the First Respondents Council, both promoting the notion that Lim should not have been found liable. Anyway, in any event, part of Lim's argument was that I should, I suppose, go back a step. The construction certificate called for the shoring to be done at the boundary to be done by way of contiguous piles, contiguous concrete piles poured very close together attached to form this effectively magnificent concrete wall underneath Mrs. Marcolongo's footings. The shoring contractor McDonald put forward to LIM as an alternative to that this sheet piling system. There was engineering reports to indicate that the sheet piling system was relevantly equivalent to the contiguous pile system. It was not suggested that there was anything negligent per se about the choice of sheet piling over contiguous piles. And so all that occurred was that that LIM said yes to the change from contiguous piles to sheet piling, and that created the circumstance, so the court found, for the negligently installed temporary propping by McDonald to come into play, because the argument was absent the change from the contiguous piles to the sheet piling, there would have been no need for the temporary props. And that was enough, according to the trial judge, to visit liability on LIM for 25% of the loss, because the argument went that LIM was subject to a construction certificate and development approval conditions that required a contiguous pile wall at the boundary. Without recourse to any consent authority, LIM elected or acquiesced in McDonald's suggestion that they swap to this vibrating sheet piles, but for that, LIM would not, the undermining of Mrs. Marcolongo's property would not have occurred. And there is, Justice Campbell spent some time on this argument, and in fact, Marcolongo is quite a useful decision in trying to understand Section 5D of the Civil Liability Act in total, but in particular, it's useful on this normative evaluation whether a defendant whether it's appropriate to visit the consequences of the harm on a particular defendant. And Justice Campbell said this, that it's appropriate for the scope of LIM's liability to extend to the harm suffered. And this is right, there was no finding by the judge, that is the trial judge, that if there had been no negligence in installation of the temporary piles, the damage would not have occurred. And just stopping there, that is true, there was not actually addressed at trial whether, but for the selection of sheet piling, had we stuck with contiguous piles, the damage would or would not have occurred. But put another way, there was no evidence to suggest that the previously specified contiguous piles would have been inadequate. And it would be an odd finding to infer that something that had been specified in the construction certificate, or at least was nominated in the construction certificate and in the consent conditions, and which had been designed by structural engineers, would have failed. But in any event, the Court of Appeal said, look, we're not asked to make such a finding, but I put the finding of appropriateness, that is, the appropriateness of LIM getting 25% of the culpability, on a wider basis. The developer made a radical departure from its own commissioned engineering design for a deep excavation in an urban area, departed deliberately from a legal requirement that attached to it having permission to carry out the works. And that's conduct that involves a very serious departure from the standards that a landowner in 21st century Australia is entitled to expect from his or her neighbour. And then, curiously, in circumstances where the judge was dealing with causation, His Honour embarked on this review of the foreseeability of what occurred and the vulnerability of Mrs. Marcolongo, all of which he put forward as reasons why it was appropriate to visit liability on LIM. And the obvious point is made that the point of imposing the duty of care on the developer is to protect against precisely the sort of damage that Mrs. Marcolongo sustained. While there was a contributing cause of the damage, namely the negligent installation of the temporary piles, the installation of those piles only occurred because it was an integral part of the sheet piling system. And so it was on that basis that LIM was held to be liable in circumstances where it seemingly its only contribution to that debacle was to acquiesce in the developer's decision, the sheet piling contractor's suggestion that they switch to vibrating sheet piles in lieu of contiguous piles. I raise that, I haven't raised it in the paper, but I raise it because I think on this related question of who's caught by the duty or whether or how widely it could be said that someone has acted in a manner, or at least has done something in relation to land that's caused a loss of support. The reasoning on causation in Marcolongo suggests a pretty broad, undemanding test for plaintiffs to establish that defendants have made some contribution to the debacle. And perhaps finish with that sentiment that's true of all Greenway CPDs.